Hello everyone and welcome to this video on statutory interpretation for A-level law. In this video what we're going to cover is why statutory interpretation is necessary. We're going to look at the rules of statutory interpretation along with the purposive approach to statutory interpretation. We're going to look at aids to interpretation and what that means and different examples. Also we're going to look at the effect of the Human Rights Act of 1998 on statutory interpretation. And finally, evaluate statutory interpretation. So like ever, we're going to begin at the beginning. So why is statutory interpretation necessary? So before that, we need to understand what a statute is. So if you remember back earlier in the course, we looked at statutes. Now, an Act of Parliament is a statute. And this is what judges are required to give effect to apply in any case. Now, you need to remember, of course, in terms of the different forms of lawmaking, statute law is supreme. So that means it's the most important, it's the highest in the hierarchy and one which must be given effect to. However, statute law is subject to how it is interpreted by the jury in the courts. So statutory interpretation then is when a statute is enacted, it's then up to the court to interpret that piece of legislation, which consequently leads to questions regarding the meaning of a word or phrase. So sometimes this can be a problem, it can be unclear about what a word means. Now sometimes it's very helpful in an act because they might have an interpretation section of an act. So for example, in the Theft Act of 1968, section 1 explains theft to be the dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it. Now, those terms are in plain English, but appropriation, for example, it might be unclear. So section 3 tells us what appropriation is. Section 4 tells us what property is. Section 5 tells us when it belongs to another. And then the mens rea of that offence, section 2 deals with dishonesty, rather what dishonesty isn't, the exceptions. And of course, section 6 deals with the intention to permanently deprive and explains what that is. So this does help judges, yet there is still common law to help explain those points, as you'll find out later on in the course. So even with interpretation sections, then there might often be problems in relation to the meaning of a statute or a word in or phrase in a statute. So to define what statutory interpretation is then, is the process a judge will go through when applying an Act of Parliament to a case over which she or he is presiding, when the meaning of the Act is not clear, or meaning of a word in the Act is not clear. And of course, it is the judge's job in a case to interpret the statute to achieve the best possible outcome. Now remember, in civil law, the judge makes a decision. So when applying the law, the judge will come out with a decision after applying the law. In criminal law, the judge has to explain to the jury, if it's in the Crown Court, what the law means. And so it's up to them then to see whether it fits in within that definition. Now, statutory interpretation is necessary because the people who draft the law, the draftsman may use broad terms and then leave it to the judge to see what situations fall within it. So for example, in Brock and DPP, the judge had to apply the Dangerous Dogs Act in 1991 and interpret that act, and wasn't sure what was meant by pit bull terrier type dog. So of course we know this from previously in the course, this act was badly drafted. Now number 2, parliamentary draftsmen may refrain from using certain words that he or she regards as implied, or ambiguous words may be used, so things which are unclear. There are also many ways in which the wording can be inadequate, so if it's an older act it might have a printing error, or it might be a drafting error. Now there might also be unforeseeable developments, okay, so in Royal College Nursing and JHS, this dealt with the Abortion Act of 1967 and the idea of nurses performing abortions as opposed to registered medical practitioners, which are doctors. Of course, we're going to look at this later on and which rule this looks at. And also changes in the use of language. So Cheeseman and DPP focused on the word passenger and how that changed over time and whether that fit in within the definition. So they're just 5 examples. There are of course quite a few more. Should you come across them, be sure to use them in any responses. So we dealt with now why statutory interpretation is necessary. Now we're going to focus on the rules of interpretation. Now together I will lump the purposive approach in with those just to be happy. So in terms of the rules, we're going to discuss the literal rule, the mischief rule, the golden rule, and of course the purposive approach. It's up to the judge in a particular case if the facts are new to actually decide which rule they're going to use. So they might use a single rule or a combination of them depending on which approach they favour. Now, this can mean the interpretation of a case can vary from judge to judge. However, once an interpretation is laid out, it can form the precedent for future judges to follow. What this means is, if a case has been heard high enough in the court hierarchy, once a decision has been made on that particular word which needs to be interpreted, that needs to be the same in all future cases. Now, you do need to know all three rules and the approach for the exam. So briefly, we can describe these rules as the literal rule, which is where the courts give the words a plain, ordinary and literal meaning, even if the result is not sensible. The golden rule. So this starts by looking at the literal meaning but can avoid interpretation of it to avoid an absurd outcome. The mischief rule gives judges more discretion. They look at what the flaws were in the law before the act was passed to see what mischief the act it was intended to cover. And finally, the purposive approach. So this looks at what Parliament was trying to achieve by creating the law and what was the purpose of that law and to give effect to that purpose. So as you can see, this is a sliding scale of rigidity, starting at very rigid at the beginning to a much more flexible approach when we go through the purposive approach. We're now going to look at each of these in turn. And of course, we're going to start with the literal rule. Now, as already mentioned, the literal rule, it was more commonly used from 80 to 50, but this is where we give the words the meaning, the literal and everyday meaning, even if this leads to an absurd outcome. Now, absurd means unjust or repugnant and may appear to be contrary to the intentions of Parliament. Now, as Lord Esher says in the Judge City of London in 1982, if the words of an act are clear, then you must follow them, even though they lead to manifest absurdity. The court has nothing to do with the question whether the legislator has committed an absurdity. So what this is doing is giving respect to Parliament's intentions. This is probably best laid out in the case of DPP and Cheeseman. Now in this case, the defendant was charged under Section 8 of the Town and Country Planning Act of 1847 of exposing his person in the street to the annoyance of passengers. Now there were two problems with this, the word street and the word passengers. Now the acts he performed were inside a public lavatory, and the word street was interpreted to mean anywhere where the council has control of. So in this particular case, the street was of course extended to the public toilet. Perhaps more famously, the word passenger was interpreted. Now, a passenger means someone who is in motion, somebody who's moving, and wayfarer, for example, or someone passing by. What that was held not to mean was the police officers who were stationed in the toilets to catch these people in the act. And so he was charged with exposing his person in the street to the annoyance of passengers. And the dictionary defined passenger as someone passing by. As the police were stationed in the toilet then, they were not passengers, so Cheeseman had not committed an offence. Now of course, this is not the effect that Parliament wanted to do in setting out this Act. However, the Act was applied literally and did not cover this offence. In Whiteley and Chapel, the defendant cast a vote under the name of a dead elector and was charged with personating a person entitled to vote. Now, a dead person is not entitled to vote, so applied literally, Whiteley and Chapel, the defendant was found not guilty of the offence as he couldn't make the offence out. Again, an absurd outcome which clearly wasn't intended by Parliament. In Fisher and Bell, the Restriction of Offensive Weapons Act of 1959 made it an offence to sell or offer for sale any flick knife. The defendant had to flick knives in his shop window and was charged with offering them for sale. Now the court found that offer to sell must be interpreted under normal contract law, and therefore having them in the shop window is only an invitation to treat or inviting people to make an offer. And so therefore he was not guilty. Now this act was obviously updated to include providing for sale, but using offer for sale An offer only occurs when a clear offer is made. This is not an offer, this is a price tag and an invitation to treat or invitation to make people an offer. So again, the defendant could not be guilty under this Act. In London and North Eastern Railways in Berryman, a man was killed when maintaining and oiling a railway track. Now his widow tried to claim compensation as he was not provided with a lookout. Now the Fatal Accidents Act stated that lookouts should only be provided for workers who were relaying or repairing the track. Now the statute again was applied literally, so Mrs. Berryman's claim failed. Maintaining and oiling is not the same as repairing or relaying, and so therefore applied literally, it led again to a repugnant or absurd outcome, but there was no compensation due to be provided under that Act. So we now dealt with the literal rule. We're now going to discuss the golden rule. Now the golden rule is sort of an extension of the literal rule and allows the court to take either a narrow or a broad construction or view of the words to be interpreted. Now you do need to know both of these constructions with case law to illustrate. Now the more narrow view is where the judges can only choose possible meanings of a word or phrase, where there are different possible meanings of a word as set out in Jones and DPP. The other view that applies the golden rule more broadly is when there's only one possible meaning of a word, but to apply it literally would lead to an absurd outcome, and therefore judges can reasonably modify words or phrases. So this is a bit more flexibility. We're changing slightly the Act, or the wording of the Act. So as ever, it's best illustrated through examples. Now, Alan is an example of the narrow approach to the golden rule. Again, just to reiterate what that is, narrow approach is where we look at different meanings of the same word. Now, under the offence, under statute, it's an offence to marry whilst your original spouse is still alive and there's been no divorce. Now, in this particular case, Alan was prosecuted under the Act, but claimed that since his second marriage was not legally valid, he hadn't committed the offence, i.e., how can I marry someone if I'm already married if it is an offence to marry? Now, the court held that the word to marry has different meanings, so it could be to become married to somebody, but also it could be to go through a marriage ceremony. And this is what they held it meant in this case, so able to avoid an absurd outcome and convict the defendant of this offence. And again, this is a narrow view of the golden rule because it uses a different meaning of the words to marry or the phrase to marry. In the case of Alder and George, the defendant was obstructing a sentry, which is a lookout, in the vicinity of a prohibited place contrary to statute. Now he appealed as he was actually inside the prohibited place at the time, and the High Court dismissed his appeal. The High Court argued that in the vicinity of should be construed as also meaning in or in the vicinity of. Clearly, if it was an offence to be near the place, it is an offence to be in the place also. And again, this is a broad application of the golden rule. In Sigsworth, perhaps the most famous example of the broad approach, a son killed his mother, and he was a next of kin and thus would have inherited all of her property according to the rules set out in the Administration and Justice Act of 1925. Now, it would have been repugnant or absurd to apply the law literally, so the court used the golden rule to avoid allowing the property to pass to the son, meaning that the next of kin cannot be where you've killed the person you're going to inherit from. So if the issue has killed the deceased, they should not receive any of the estate. So they changed the phrasing, therefore, of the next of kin. So we now dealt with the golden rule. We're now going to look at the mischief rule. Now the mischief rule gives the judge more discretion again, so we talked about that sliding scale earlier on in the video than the other two rules. The definition comes from Hayden's case in 1584, and this sets out the guidelines for when the rules should be used. So this is not necessarily something that can use all the time. It does need to fit within these guidelines. So what was the common law before the Act was passed? This is the first thing we need to consider. What was the common law? Secondly, what was the mischief the Act was designed to remedy? So this is what the problem was. Why was the Act created? Thirdly, what was the remedy that the Parliament tried to provide? And finally, what was the true reason for that remedy? Now, the judge should look at the mischief the act was intended to remedy and interpret the act in such a way that the remedy is achieved. So what we're doing is we're looking at what the outcome was intended to be and trying to give effect to that outcome. Now, under the mischief rule, the court should look to see what the law was before the act was passed in order to discover what gap or mischief the act was intended to cover. Now, the court should then interpret the act in such a way that the gap is covered. So remember, mischief is the problem in the law. The most famous example of this is Smith and Hughes. Now, the Street Offences Act of 1959 made it an offence to solicit in a street or public place. Now, in this case, some prostitutes were behind windows and on balconies calling to the men who were passing by. Now, under the literal rule, they wouldn't have been guilty because they were not in the street. Now, using the mischief rule, the judges decided that the mischief the act was designed to prevent was men being harassed by prostitutes, and so therefore give effect to that and made the defendant guilty. Now, Lord Parker said, everybody knows that this was an act intended to clean up the streets. Now, as the men were still being harassed by the prostitutes on the street, the men were on the street, they were still guilty. The Royal College of Nursing and DHSS, again, the mischief rule was used. Now, the Abortion Act of 1967 said abortion should only be carried out by registered medical practitioners, who, in this case, doctors. Now, nurses carried out part of the abortion procedure under the instruction of doctors. Now, under the literal rule, they would have been acting unlawfully. However, the mischief the act was supposed to stop was backstreet abortions, as in dangerous backstreet abortions, not nurses carrying out the procedure safely in the hospital. So they were found to have acted lawfully and therefore hadn't broken the law. In Eastbourne and Stirling, in this particular case, a taxi driver was charged with applying for hire in any street without a licence to do so. Now, it was argued he was parking in a taxi rank on a forecourt and not in the street. But if we think back then to Smith and Hughes, which was a precedent used in this case. Now, the court said he was likely to get business from people in the street and therefore used this precedent of Smith and Hughes to find him guilty. And again, the mischief here was to stop people, stop taxis driving without a licence to pick up passengers. In Bradford and Wilson, a man was arrested in his car where he'd been sniffing glue. Now, he was charged of being in charge of a motor vehicle while unfit through drink or drugs under the Road Traffic Act of 1972. Now, he appealed against his conviction on the grounds that glue is not a drug. Now, his appeal was dismissed, and again the mischief rule was applied. If we look at the common law before, so we look at the mischief in this particular case, the mischief was to stop people driving when they're impaired. And in this case, if glue is going to impair them, then it fits within this act, and so he was found guilty. So we now looked at the mischief rule. We're now going to look at the purposive approach. Now, the purposive approach, you may get a little confused with the differences between this and the mischief rule, because what both of them do is try to establish what Parliament intended to do. Now, this purposive approach is the more modern approach. It focuses on the intention of Parliament, i.e. the spirit of the law, and not the words Parliament used. So it still respects parliamentary supremacy because it looks at what they intended to do and tries to correct any misconceptions or errors. Some may argue, though, it doesn't follow parliamentary supremacy because they wrote down exactly what they wanted to happen. Now, what this does is it asks what Parliament was trying to do when they passed the law. Now, if we compare the mischief rule and the purposive approach, now the mischief rule looks backwards. It looks at the problem with the common law, so this is a negative approach. Whereas the purposive approach looks at what Parliament tries to achieve, so it's proactive, it's positive. Let's look at some examples. So, the Jones and Tower Boot Company, in this particular case, a black worker brought proceedings against his employer under the Race Relations Act of 1976 for the racial abuse he suffered from his colleagues. Now, a tribunal dismissed this case as racial abuse where workmates were not literally acting in the course of employment. Now, this, if you remember, you will go through in the further on the course when you look at vicarious liability. Now, this is where employees are made liable for actions of their employees. Now, they will never be liable if they're not acting in the course of employment. However, they held that the Court of Appeal allowed the appeal and said that the purpose of the Act, Parliament's intentions, was to eliminate racial discrimination, and this claim was successful. So the argument about course of employment there, going back to that, is that they're not paid to be racist, they're not paid to discriminate, so they're not doing the job. Now, of course, there is some weight to that argument. However, the court applied the Act in a purposeful way, or the purposive way, to achieve a just outcome. Now, in the case of the Crown and Registrar General ex parte Smith, now Smith, the defendant in this case, was a baby. He had killed twice, and he was in Broadmoor, which is a secure psychiatric unit. Now, if using the literal rule, he should have had absolute rights to his birth records to be able to find his birth mother. However, the court denied him access to his records, because clearly, if we apply the purposive approach, the argument is that Parliament could not have intended to put his natural mother at risk. Now, in this case, the argument was he might have killed her had he come into contact with her. And so, therefore, he was not allowed his records. We used a purposive approach to look at the effect Parliament wanted to do. It's not looking at the problem, looking at what the effect should be. Now, in Quinterville, or to give the case its full name, the Crown, on the application of Quinterville and the Human Fertilisation and Embryology Authority, there was a test as to whether an embryo is only when an egg has been fertilised. Now, the Human Fertilisation and Embryology Act was passed in 1990 when fertilisation was the only way to create an embryo. Now, a technique was developed in 2003 called cell nuclear replacement. Now, no fertilisation takes place here. A nucleus from a fertilised egg is removed, placed into an adult cell, and then the cell divides or creates clones. Now, to understand whether this was still an embryo, the purposive approach was taken by Parliament. Now, clearly Parliament could not have foreseen this development in 1990 or before 1990 when the Act was discussed and debated. And of course, Parliament would not have intended to dismiss an embryo created this way as something other than an embryo. Okay, so we've now looked at the rules of statutory interpretation. We've also looked at the purposive approach. We're now going to focus on the aids to interpretation. So the aids to interpretation are things which can help a judge to understand what a word means when it's unclear, or to gain an understanding of what the phrase is. Now, we have two types. We have intrinsic or internal aids, which means things that can be found in the statute itself to help the court understand what Parliament intended, or extrinsic or external aids, which are sources of information outside of the statute which can help. So in terms of internal aids, there are things found inside the Act of Parliament. So we've looked at how to label an Act of Parliament already. And in this particular case, you've got an Act in front of you. You might have the long and short title of the Act. Now, in the Royal College of Nurses, the judges referred to the long title of the Act, the Abortion Act. And the long title said, "An Act to amend and clarify the law relating to the termination of pregnancy by registered medical practitioners." We also might have a preamble. Now, not so much anymore, but older acts have statements at the start of the act setting out its purpose. Why was the act created? For example, the Theft Act 1968 states in its preamble that it aims to modernise the law of theft. We also might have an interpretation section, as mentioned earlier on in this video. The Theft Act is a good example here. The Act contains interpretation sections which explain keywords in the Act. We might look at marginal notes. So this explains different sections. Now, it's not generally regarded as giving Parliament's intentions, but they're put in after parliamentary debate by the person drafting the Act. Or we might have headings before a group of sections, or schedules at the end, which may clarify particular points. So it's essential to view the whole Act, or the Act as a whole, before applying it. You might also look at punctuation. So punctuation is important. This might be a bugbear for some English students out there. But consider this phrase: the panda eats shoots and leaves is different from the panda eats shoots and leaves. Now, in the Hanlon and Law Society, Lord Lowry said that judges should look at the importance of this when interpreting Act of Parliament. Now, it seems a little patronising to consider punctuation, but it is important to consider it. Here's another example here: let's eat grandma, or let's eat grandma. Of course, is different. Now, other internal aids then, we have words of the statute or sections of the same statute which may explain or give further context to the word. We also have then external or extrinsic aids, and these are things outside the Act which might help to understand a particular Act. Now, one key example is Hansard. Now, Hansard is a record of the debates in Parliament. Now, since the case of Pepper and Hart, Hansard's been allowed to understand what Parliament's intentions were. Now, what better way can you find to understand Hansard's intentions, Parliament's intentions, through other than records of the debates, the things that they discussed? You could also look at previous acts. So when looking at, for example, the Mischief rule, you might look at the act in the past and the problems or the gaps it had in order to understand what the new act is trying to achieve. You might also look at legal textbooks. Law reports, these give cases, or these will look at precedents and how the law has been applied in the past. Or you might look at an EU treaty. Now, of course, as members of the European Union, this would have been important, but not so much as of now in our legal system. Now, as mentioned before, Hansard, so it's a written record of all parliamentary debates. It can be used when the words of an act are ambiguous, obscure, or lead to an absurdity, or there's a clear statement by the minister introducing the act that would resolve any doubt as to what the intentions were. Now, when judges use the Mischief rule or Purposive approach, it's very useful to be able to look at what Parliament was intended. As Lord Denning said, that not using Hansard is like groping around in the dark for the meaning of an act without switching on the light. So the act must be ambiguous or obscure, or literal interpretation would lead to an absurdity then. And the judges may only look at statements made by a minister or other promoter of the bill. Again, this gives the effect to the intentions of Parliament. Now, the statements must be clear in order for them to be relied upon, and Hansard is useful when the judge is applying the Mischief or Purposive approach. We might also use dictionaries, and this seems obvious, but the ordinary meaning of the word then, if we're using a literal rule, for example, may be used in dictionaries, but we need to make sure that we use it from the time of the Act. So the Town and Country Planning Act of 1847, you need to use a dictionary from 1847 to understand in Cheeseman, for example, what passenger meant. Now, two other examples, in Vaughan and Vaughan, they looked at what molest meant, and in Macfarlane, the definition of what a prostitute is. So those then are the aids to interpretation. We're now going to look at the effect of the Human Rights Act on statutory interpretation. So Section 3 of the Human Rights Act of 1998 tells us, so far as it's possible to do so, primary legislation and subordinate legislation must be read and given effect to in a way which is compatible with the Convention rights. So what that means is, if any rights are to be breached, then of course we should interpret it in a different way. A famous case is Guy and Mendoza, and in this case this concerned the Rent Act of 1977, which applied where a person who was renting a house or flat died. Now, the Act set out that if the original tenant had been living with another person as their husband or wife, then that person could continue to rent the property. The Act also applied to unmarried partners, but the question in this case was, should same-sex partners have had the same right to take over the tenancy? Now, bear in mind, this is before much modernisation of the law, even from 2004. Now, both the Court of Appeal and House of Lords found the Act would apply to same-sex partners. There was no other reason that it shouldn't. Now, if it was read any other way, it would be incompatible with the European Convention on Human Rights and the Human Rights Act. And so they found that the person in question could continue to rent the property. So that then is the effect of the Human Rights Act of 1998. We're now going to focus on the evaluation. So we're going to look at some key advantages and disadvantages of the literal rule, the golden rule, the mischief rule, and of course the purposive approach. So remember, when outlining some advantages, we need to try as much as possible to use the PEE method. So give a point, explain it, give an example, or give a point, give an example, and explain how that example proves your point. So in terms of the literal rule, remember this is where we give the dictionary definition to a word or the literal ordinary everyday meaning. Now, advantages of the literal rule then are it leads to predictable or certain outcomes. Now, if a judge interprets the words in an act exactly as they're written, it's easier for people to know that the law is and how judges are going to apply it. This is better than the uncertainty of judges trying to work out what Parliament intended. So comparing that to the purposive approach or the mischief approach. Mischief rule, sorry. It means solicitors can advise clients on the likely outcome of a case. Now it's democratic then, it respects parliamentary sovereignty and of course the separation of powers. What it also does is restrict the role of a judge. So if they're only allowed to give effect to what Parliament wrote, then of course that restricts the role of a judge. They're applying the will of the Parliament, therefore not making law. It might also draw Parliament's attention to drafting errors. So for example, Fisher and Bell, the strict application of the words offer for sale prompted Parliament later to amend this to displaying flick knives for sale. Or displaying flick knives. So it does alert them, so when they think, oh, we've drafted that wrong, they need to then go and change the law. Disadvantages of the literal rule then could include it can lead to absurd results. So all of the cases we looked at in that particular section of this video led to an absurd result. So Whiteley and Chappell, for example, it seems absurd that someone would be guilty if they impersonated a live person, but not if they impersonated a dead person. The outcome doesn't reflect Parliament's intentions, which was to stop all kinds of electoral fraud. It can lead to fair results or unfair results. So Berryman, for example, she was unable to claim her husband was held to be maintaining, not relaying or repairing a track, as we looked at earlier on. It doesn't seem to be fair, so his job's just as dangerous maintaining as it is relaying or repairing. Why not provide a lookout? And why not provide compensation if you don't do that? And finally, Parliament may need to rectify an error following a case, as we discussed in Fisher and Bell, which means that they've wasted time. It does assume that acts are perfectly drafted, which they are often not. And it can't be used if words have more than one meaning. We need to, of course, then use the golden rule. Now, some advantages of the golden rule, and remember in this particular case then, so we have the narrow approach in which you look at different meanings of the word, or we have the broad approach in which you may modify the phrasing slightly. Now, this does respect the words of Parliament as judges apply the literal rule first. With the narrow approach, judges may only choose between dictionary meanings of the word in a statute. Now, this preserves parliamentary sovereignty as judges are interpreting the law and lawmaking is left to Parliament. It prevents absurd and unfair results that may be produced from applying the literal rule. It therefore allows sensible decisions. Now, in Allen, you would explain the facts of the case, of course, in your work, and go on to outline the different meanings of Tamari and how that led to a better outcome. Now, the narrow version is a straightforward logical extension of the literal rule. If there's more than one meaning, why wouldn't we choose the right one? And the broad approach allows just decisions. Okay, so just decisions are fair decisions in which you modify the phrase and lead to a more just outcome. Now, of course, you can use Sigsworth there. You can explain the facts of that and explain why it was not an absurd outcome. Looking at disadvantages of the golden rule then. Now, this is subjective. So each judge has to decide what an absurd outcome is, and each judge may decide differently. So for example, if you compare Allen with Cheeseman, now in both cases the defendant was obviously guilty of a crime, but in Allen they were convicted by using the golden rule, while in Cheeseman the defendant was later acquitted because of the literal rule. Now why wouldn't they be consistent? This could be a problem. Now as it's not clear when the golden rule be used, it makes the law a little unpredictable, therefore difficult for lawyers to advise their clients on what the outcome of a case is likely to be. Now the broad approach allows judges to add words to a statute, so this is giving the judge in effect too much power. They're not elected, and so it's undemocratic and against the separation of powers theory in which we have lawmakers and people who apply the law. Now, Michael Zander, a legal academic, describes the golden rule as a feeble parachute. It can be an escape from the unfair decisions caused by the literal rule, but it's not clear when it's going to be used, so it's of limited effectiveness. Now, we're going to look at the mischief rule, and there's some positive points about the mischief rule, some advantages. Well, this helps fill in gaps in the law. Now, remember, this looks at the problem and looks about Parliament and the remedy they tried to give to that problem. Now, no law can be drafted perfectly, and there'll be circumstances where a law needs to be applied in a way the draftsman didn't predict. So, with Smith and Hughes, the mischief rule stopped the prosecutors being able to exploit a loophole in the law. Now, mischief rule can adapt to changes in society also. So, in the Royal College of Nursing and the GHSS, where registered medical practitioners could perform abortions. Now, Parliament had not anticipated advances in medicine would mean nurses could also carry out abortions. Now, the mischief here was to stop backstreet abortions, not nurses carried out safely, so they were lawful, and of course this helps to ensure that they're not illegal, performing illegal acts. Now, this does then, the mischief rule also helps avoid injustice and absurd decisions caused in cases like Berryman. And the Law Commission have, as far back as 1969, said this is the only rule that should be used. So, some disadvantages: if an act is old, it can be difficult to understand what Parliament's intentions were or the common law they were trying to solve. Even with access to Hansard, it can still be difficult to understand the intentions. There is sometimes a disconnect between the courts and the legislator. Now, it can also make law uncertain. Now, it was created as far back as 1584, but has not been applied consistently since. And also what we got here is there's a risk of judicial lawmaking, which then is undemocratic because it undermines parliamentary sovereignty, as in giving Parliament's words the exact intention or effect they should have. And finally, the Law Commission said the purposive approach was a better way of fulfilling the goals of legislative purpose. So even the Law Commission have moved over to criticising, and perhaps it's not as wide-ranging as the purposive approach, and indeed the purposive approach maybe is the one that should be used. So this is the more modern way of doing things, the purposive approach now. Now, some advantages of the purposive approach: it gives effect to the true intention of Parliament, so the judge looks at in the context the act was passed and allows interpretation which is much closer to what Parliament intended. Now, since pepper and heart, Hansard can be used, as we know. Now, the purposive approach as well as provides consistency across Europe. This is the approach taken in all European countries and by the European Court of Justice. Now, as different countries and languages are involved in drafting EU law, a literal translation would of course be practical. Now, in terms of its effect, of course, in terms of EU law and being consistent with EU, this isn't as important now as it would be, but of course it's still an approach the judges will take regardless of no longer being members of the European Union. Now, the purposive approach produces fair and reasonable outcomes, so you should explain how the purposive approach is used in Jones and Talbot Company, for example, if you used the PEE method, in which there was a just outcome despite the fact that if applied literally, there would have been no compensation. And finally, we have the disadvantages of the purposive approach. So what this does is allow unelected judges to make law. Again, this goes against the idea of parliamentary sovereignty and undemocratic, and is against the separation of powers. Now, Lord Simmons says the purposive approach is a naked usurpation of the legislative function under the thin guise of interpretation. So what we're saying is judges have too much power pretending to interpret the law when in fact they are making law. Now, we have legislator and we have people who apply the law, and we need to make sure they're separate, and this blurs that line. Now, it can be difficult for judges to identify what Parliament intended when they passed the Act, and the purposive approach allows for judicial creativity, which means each judge can come to different conclusions about Parliament's intentions. So it could mean that the Acts are almost not worth the paper that they are indeed printed on. So that's statutory interpretation in a nutshell. Of course, there is more information you may come across or use, but that does give an overview of the topic. So we looked at why statutory interpretation is necessary, we've looked at the rules, we looked at the purposive approach, we looked at aids, we looked at the effect of Human Rights Act, and finally the evaluation of statutory interpretation.